Hello and welcome to Conversations with the Voice of Reason. I'm your host, Benjamin Boyce, and today's conversant is returning guest Leor Sapir, who is a fellow at the Manhattan Institute and a PhD in constitutional government. In this conversation, we talk about his main work right now, which is focusing on the legal aspect of child gender medicine, which is now being reviewed by the Supreme Court of the United States. And in this conversation, we get into the minutiae of the legal aspects of this issue and what that says not only about our culture and our time, but our legal system and how that shapes our culture and our time. Leor is a great guy. You can follow him on Twitter and at the Manhattan Institute, links to which are down there in the description, as well as links to support this channel if you so desire. Without further ado, here is Leor Sapir. Well, I wanted to catch up on the state of the gender situation legally, broadly, and then also what your thoughts are on how that reflects like the broader political landscape. Really big
Sure.
topics, so we can go
Yeah.
wherever you want, wherever you feel itching to go.
You decide. I'm flexible.
Well, what have you been working on? I guess just this year and then most recently.
Well, the last few weeks have been consumed by the SCMET case, as is probably true for quite a few of the people in this area.
Mm-hmm.
Um, I'm about to publish the my commentary on the deposition of Eli Coleman, who is the chair of the WPATH Standards of Care 8 guideline committee. It's going to be the third article in a series that I've written about the depositions of key figures within the world of gender medicine. The
Mm.
previous one was on Meredith McNamara, and then before that, Jack Turbin. Um, and other than that, we're also gearing up to help, anybody in the incoming Trump administration who is trying to understand what the administration can do to try to undo some of the more damaging policies of its predecessor, to try to hold accountable those who need to be held accountable.
Hmm.
We're working on, articles, memos, things like that.
Yeah.
The usual think tank work.
Yeah. Yeah. What does accountability look like?
Oh, that's a good question. Well, I assume that you mean for the doctors who are actually administering these procedures, writing prescriptions. Is that what you mean?
Well, I guess we would have to lay the groundwork for who is responsible and what are we talking about?
Yeah,
I guess just within gender youth
yeah,
medicine or youth gender medicine, like who's responsible for that, and then you divvy that out because the doctors. This is one problem with the whole situation. The doctors point to the guidelines
right,
people. The guidelines point to the professional orgs, and the professional orgs figure out another professional org to point
right,
to.
right. Yeah, I mean, look, obviously the professional organizations bear a great deal of responsibility here. Um, I think, if you had asked me in 2019 or 2020 to what degree they are culpable, with the exception of WPATH, if we're talking about the American Academy of Pediatrics, the Endocrine Society, the American Medical Association, I would have been a little bit more charitable. I would have said, look, this is what, Stephen Levin has called the broken chain of trust. It's very common in medicine, given how specialized a field of knowledge it's become in the last century. It's extremely common for doctors to develop sub areas of specialization and to defer to other doctors who they believe are experts in a particular niche topic of research or clinical practice. And so it's not that uncommon for doctors to say, look, this might sound a little bizarre to me, but, I'm going to defer to my colleagues. They're the ones who have spent their entire careers in this area. Who am I to question them? I don't know the research. They presumably do. So I would have been a little bit more charitable to organizations like the AAP back then. But, over the last 5 years, I think we've developed a very strong public record of the lying, the manipulation, And most importantly, of the fact that their own recommendations are simply not based on credible evidence. They ignore bedrock principles of evidence-based medicine. They don't adhere to basic norms of medical ethics. Um, and so, given all that public criticism in the last 5 years, some of which happened, on the pages of the Wall Street Journal and high-profile
Hmm.
exchanges, I participated in those exchanges with the president of the AAP. I think it's become no longer possible for these organizations to deny that, that they knew that there was a problem here. And so what does culpability look like? Well, this is not the first medical scandal that medical associations are responsible for. Think opioid epidemic, peanut allergy recommendations
Hmm.
by the AAP and so on and so forth. But this is one of the most grotesque, just in terms of, its consequences. Um, so what could accountability look like? Well, I think for one, I think a lot of people would like to see lawsuits against these organizations. That is very difficult to do.
Hmm.
For legal reasons, it's very difficult to do. I mean, there could be some consumer protection clauses at the state or federal level that might be invoked. The AAP is currently a defendant in one lawsuit by a detransitioner, by a former patient of Jason Rafferty's. Presumably state attorneys general can launch investigations into these groups for fraud. But at the end of the day, I think the more plausible penalty that they could face is the revocation of their C3 tax status.
Hmm.
I would certainly like to see something like that happen with WPATH. I don't think WPATH should continue to exist. I think it's proven itself rotten to the core. I think other organizations, even though they've been kind of woke captured, the AAP and Endocrine Society and so on and so forth, they have an important role to play, especially in the absence of a centralized healthcare system like the Europeans have. These
Hmm.
medical groups can be critical instruments in the dissemination of medical knowledge. Although their primary role, of course, is trade unions. They're essentially doctor advocacy organizations,
Yeah.
which has a role too, right? I mean, it's all part of the ecosystem.
Yeah.
But revoking their tax status seems like, for at least for WPATH, seems like the minimum that should be done.
Hmm.
Defunding, that would require the AAP, for example, gets a third of its funding from member dues. And so getting members to stop being members, to stop sending in dues, to give up their membership. I know that some AAP members already have, but not nearly enough,
Yeah.
apparently. But I think a credible threat of a significant portion of pediatricians across the United States saying, hey, if you guys don't back down from these positions, which are dangerous, we're no longer going to be members. I think that could have a significant effect as well.
Yeah.
So that's the medical associations. I mean, we could talk about, the individual clinicians, we could talk about hospitals, we could talk about these sorts of things, but the medical associations for me bear a great deal of responsibility here.
Just speaking to the medical associations, have you seen any signal that they feel on the ropes or that they're being shaken a little bit about the trade winds or whatnot?
Yeah, I mean, it's hard to recall from memory, but we have seen some of these examples in the last few months. It happens, for example, the AAP sent out an email to its members saying, I can't remember the exact details, but something like, don't communicate through emails that can be FOIA'd, something like that, right? So they know that they are
Okay.
under the microscope right now.
Yeah.
And, I think look, are there true believers in these organizations? Of course. Are they, the dominant voices in the leadership committees? Probably not. So if you're looking again at the AAP, you have Mark Del Monte, who's the CEO of WPATH. He's a lawyer. He's not a doctor. If I had to guess, I would say that he knows that his organization has dug itself in a hole. But he's not quite sure how to get it out. Because, to admit the mistake would not only expose the AAP and its members to legal liability, But it would also, undermine its own credibility with its members, with
Yeah.
its funders. It could lead to a loss of membership. But at the same time, if he just continues to steer the ship in the kind of the gender affirming direction, it's inevitable, right? It's
Yeah.
this is the Titanic. It's going to sink at some point.
Yeah.
Maybe he's hoping that it won't sink on his shift. So
Jeez,
there's
man.
also a lot of self-interest, right? These are human
Yeah.
beings, and all of us are motivated to some extent by self-interest. So there could be just self-interest here that he wants to just steer the ship until he's out of there.
Yeah.
Who knows? Who
Yeah.
knows?
Is it just seems like indicative of a lack of leadership in these professional organizations, or
Right.
leadership that's non-ideological, at least.
Yeah, I think that's right. And again, you can ascribe motives to somebody like Del Monte that are ideological, but also that are non-ideological, right? I just tried to explain in terms of just purely kind of narrow self-interest why he would not back away from the gender affirming stance, even if he thinks that it's incorrect, even if he thinks that the AAP, unfortunately got embroiled on this issue because it deferred to a small subcommittee on LGBTQ health, thinking that the 6 people on that committee would never, you know, make
Hmm.
bad recommendations. By the time it was publicly revealed that they had, the AAP had already endorsed them and called anybody who disagrees a bigot.
Yeah.
So sometimes, look, I mean, this is a pattern in politics and policymaking, in the way social institutions operate. It's not always the case that you have ideologues who have a clear idea of where they're going and what they want to do, who just kind of impose a mandate and then stick with it. I would say it's far more common for institutions and government agencies to take small steps, incremental steps, believing that they're still treading on safe grounds and not exactly seeing where these small steps are going to end up leading them. And then by the time they get to that, troubling location, and they look back and they say, "Wow, we didn't think that we were going to end up here, but here we are." I mean, that's usually the pattern of these
Yeah.
things.
Yeah. Do you believe that the mechanism of the law is robust enough at this point to correct or to impose correction on
Well, that
these
depends on
institutions?
what areas of law and what types of regulations. So maybe we should break it down a little bit because we have state bans on youth gender transition.
Hmm.
We have, you know, very recently we have congressional enactments to defund, gender medicine. For example, at Tricare, which is the military insurance,
Hmm.
it just passed the House with 50 Democrats, I think, signing on to it.
Really?
Yeah,
Is Tricare, does that treat like the youth of
yes,
military service members? Oh, okay.
that's correct. Yeah.
And so that's been going on, like the transing of military brats?
Oh, yeah. Yeah, there's a couple papers that were published in 2022, based on data from the military health insurance records. So the Christina Roberts study of 2023, that's if you've ever heard the statistic that up to 30% of adolescents who start on the hormonal pathway end
Okay.
up dropping out of it within 5 years or something like that. I can't remember the exact number. That's the Christina Roberts study from 2022. That's based on
Okay.
military health insurance
Data.
records.
Okay.
So that's another example, right? And then, of course, you have the all-important but extremely difficult to win detransition lawsuits. The most important, I think, of which was recently filed against Johanna Olson Kennedy.
Hmm.
That's Clementine Breen's lawsuit in California. So these are the three kind of most visible aspects of the pushback against gender medicine, right? The state bans, the malpractice lawsuits, and the public insurance defunding. But there's other measures underway, investigations by the House committee investigations of the NIH and its funding for Johanna Olson Kennedy's study.
Hmm.
Um, you
Which
know,
she reneged on, or she suppressed the
Yeah,
research?
right. So there was an article that came out in the New York Times a couple of months ago that exposed that she was sitting on the results of mental health outcomes in the puberty blocking segment of her study. because the results were disappointing, and she was worried that they would be, quote, weaponized.
Yeah, or
um,
politicized.
or
Yeah.
politicized. Yeah, whatever. I can't remember the exact word that she used, something like
Well, but
that.
she wanted to politicize them if they went in her favor.
Of
So,
course, but she doesn't
oh,
see that as politicization, right?
okay. Yeah, no, that's just rights. Just
Right.
rights.
That's just medicine, right? That's just how things work. But of course,
Hmm.
if the results are disappointing and critics point to those disappointing results and say, "Hey, you're giving kids medication, but your own data suggests that it doesn't work,"
Yeah,
then that's politicization, apparently.
yeah.
Um, so yeah, so we can talk about, any one of those areas
Do
of.
Under what parameters are private gender clinics responsible or able to be held accountable? If they're, I
Mm.
guess, if they're getting insurance money or parents are just paying for their children to be transed, like what law regulates these private clinics
Uh,
or
that's a good
NGO?
question.
And are they a
Yeah.
significant modicum of this transition? Youth transition, like the private stuff, or is it children's health? From your point of view, is it children's hospitals, like more public domain, or public and private partnerships of some sort?
Y- Yeah, I'm not sure I can give you a really good answer on that. I mean, the children's hospitals actually, if memory serves, I think the Do No Harm data found this. The children's hospitals actually make up a relatively small proportion of
Okay.
pediatric gender interventions.
Hmm.
Even though they kind of have an outsized name in the
Yeah.
field, right? Because sometimes they're just called the Pediatric Gender Medical, Center at some fancy university hospital. Um, and of course, these, if they're at academic institutions, academic hospitals, then they attract a lot more money and attention and big names in the field. Um, and actually, we at the Manhattan Institute have been engaged in an ongoing insurance database analysis.
Hmm.
And one of the things that we found is that actually, when you're trying to look at gender clinics as a discrete entity, from an insurance perspective, they don't really exist.
Hmm.
In other words, these are doctors who kind of rotate in and out. They have part-time appointments. You have to look kind of on an individual provider level. And even then, it's hard to say, this provider, when did they provide this treatment to this patient at this place, as opposed to a separate, private clinic or satellite clinic or something like that. So it gets very messy.
Yeah.
But look, I mean, just to get back to what I think most people care about right now, the Skermeti case is going to be decisive for what happens in the red states. It's going to have ripple effects beyond the red states, of course, but
Yeah.
it's going to be decisive for the red states. And I think the concern in the blue states among those who are kind of trying to push back and hold accountable the gender industry is that, kind of if the Supreme Court decides in favor of Tennessee, that will deplete a lot of the motivation among critics of gender medicine and activists and researchers and so on and so forth to try to get some stuff done in the blue states. And that's understandable, right? I mean, the blue states are where a lot of this stuff is happening. California, for example. And
Hmm.
it's a very difficult nut to crack there, right? Because by definition, you're not going to get any traction with the executive branch, with the legislatures there. There's partial exceptions. Some
Hmm.
purple states like New Hampshire have passed, surgical bans and stuff like that. But by and large, you're not going to get California to pass a ban or even any form of restriction on youth gender transition. On the contrary, they're just going to keep passing their sanctuary state laws and beefing up protections for kids coming from out of state to get those
Yeah.
interventions. So that's exactly why, the malpractice lawsuits are so important because, even one or two hard-hitting malpractice lawsuits that land a $10 million plus settlement for the plaintiffs um, are going to send a chilling effect through the entire malpractice insurance industry.
Mm.
And, we've already seen a few examples of malpractice insurers in places like Chicago, increasing their premiums significantly for any provider who wants to provide these types of interventions. In some cases, they have outright excluded them from their policies. They'll just say, we don't cover this. But there's two things that I would say about that. Number one, I could see a situation in which Democrats in blue states and potentially Democrats at the federal level, if and when they retake, the federal government, will just underwrite the malpractice costs, the malpractice liability costs.
Yeah, that's what I was going to ask. You think the state will absorb that?
Yeah, they could definitely do that, and they probably will do that. But the other thing is,
absorb anything? Yeah. Is there any precedent for them absorbing the malpractice costs of other interventions?
That's a good question. I'm not sure. It's a good question.
It's really interesting that this is the hill that they'll break the bank
over. Yeah, but look, this is lawfare, right? This is and lawfare is just a series of steps of maneuvers and counter maneuvers, right? And so you always have to be one step ahead of the other side and anticipate what they're going to do and try to kind of
cut them off at the pass.
Right. But the other problem here is that medical malpractice insurance actually makes it more enticing for lawyers to take detransition cases against providers because then there's a deep pocket for a payout. So Siv Gallagher, the plastic surgeon from Florida who goes on TikTok and boasts about yeeting teats and makes a lot of money from that kind of stuff. She notoriously does not carry malpractice insurance. Why? Exactly for why you'd expect, because she knows that if she carries malpractice insurance, she'll be a high value target to tort lawyers, right? Yeah. To plaintiff lawyers. Without malpractice insurance, there's only
she can only pay so much,
right? And so she's she believes, probably correctly, at least in the short term, that she can insulate herself against legal liability in that way.
Okay, yeah.
So one thing lawmakers can do is require gender clinics and gender clinicians to carry malpractice insurance. And then the combination of that requirement plus malpractice insurers, significantly increasing their premiums can be pretty devastating for the gender industry in blue states.
So it's always beguiled me that I guess it's kind of just the nature of federalism, but one state can declare that transing a kid is child abuse, and then another state can declare that not transing a kid is child abuse. Right. There's no ultimate arbiter of this very essential question, what is it to abuse a child? That should be on the top of the docket on, what's proper behavior in a society.
That's right.
What do you think about that, or how has this become the crux? Is it the crux of state, just the difference of our visions as a country?
I think it is. And look, the question of what constitutes abuse is now a very relevant question in line policy. The Biden administration, through a number of channels, tried to redefine abuse kind of consistent with what LGBT organizations, and we should talk about those as well. We should come back to that if we have a moment. The Biden administration has tried to redefine the term abuse consistent with how LGBT groups, I should say trans activist groups, have done so over the last couple of years, which is to say withholding of affirmation, gender affirmation, constitutes abuse. Now, of course, this started kind of, at the level of rhetoric and journalism and stuff like that among trans activists, but of course it quickly filtered into law and policy. And so just to give you an example, and I wrote about this with my colleague Joe Figlioli at City Journal and the Manhattan Institute Journal, the Department of Health and Human Services has a special agency dealing with foster care. And the Biden administration proposed a rule for foster care that basically stipulated that parents have to be gender affirming if they're going to be eligible to be foster parents, which of course means, number one, that you are taking off the table parents who are more informed on this topic and likely more responsible. And number two, more importantly, you're leaving kids who are already very vulnerable within the foster care system that much more exposed to, harmful practices. So in any case, the question of what constitutes abuse is, of course, secondary. It's downstream of these more fundamental questions of, you know, is sex assigned at birth? What is gender identity? Are some kids transgender? What does it even mean to say that? Is gender affirming care, ethical? Is it science-based, and so on and so forth? So people, can obviously get engaged in the child abuse discussion, but at the end of the day, like if you don't go upstream to these more fundamental questions, it's really
Really?
difficult to solve that
Yeah.
question.
Is the SCMET case going to answer that question that was proposed to the most recent? I always forget her name. Kimji. The question about what is a woman. The most recent.
Ketanji Brown Jackson.
Ketanji Brown Jackson. Yeah, she
Yeah.
refused to answer that. Well,
Well,
she
she's not a
deferred to the science.
biologist.
Yeah, she's not a biologist.
Right.
Is the law with this case going to be able to implement sex realism in the law? Is it going to see that that's necessary to make further claims or to make further adjudications?
Um, okay, so let's talk about a little bit about Scarbetti because it's a very interesting case. Not least because, as I'll explain in a minute, it's actually the Department of Justice, the Biden administration itself, was arguing a pretty sex realist case. Its
Okay.
arguments actually presupposed the binary and biological nature of sex in order to be able to make an argument about sex classification in Tennessee's HB1 in the bill that's being contested. But look, I mean, on the surface, no, the case and, assuming the Supreme Court, I'm not quite as optimistic as other people that we're going to see a 6-3 break here in favor of Tennessee. I could see a 5-4. I could even see a 4-5 loss, to be honest.
Hmm.
I'm not, I'm optimistic, but cautiously so. But no, I mean, the question before the court is a relatively narrow one. It's a very important one, but it's relatively narrow. It's simply, did the Sixth Circuit apply the correct standard of judicial scrutiny when reviewing HB1? So, narrowly, it's a case about what standard of review under the Equal Protection Clause of the 14th Amendment should the lower courts apply when reviewing laws like HB1? Should it be a rational basis standard, which is the lowest standard, and which says, as long as there is some conceivable rational justification for the law, it doesn't even have to be the actual justification that the lawmakers gave or used or had in their minds. It just has to be possible. And as long as there is some plausible link between the law's mechanisms, the means of the law, and the ends of the law, then the courts simply defer. They're not going to strike down the law. And under a rational basis scrutiny, laws are pretty much always left to stand.
Hmm.
At the other end of the spectrum, you have what's known as strict scrutiny, and that is the jurisprudence that developed during the civil rights era, reaching all the way back to 1938 in the famous Caroline Products case at the Supreme Court. The famous footnote 4 introduced this entire kind of mode of analysis in which courts say if there is a classification based on race, the courts are going to take a very, very close look at the law and its motivations and its stated aims. And only if there's an extremely compelling justification and there's no narrower way to achieve the stated end of the law, the court is going to strike down the law. And then in the middle, you have what's known as intermediate review, or sometimes it's called heightened scrutiny. And this is a standard between rational basis and strict scrutiny that developed in the wake of the women's movement of the 1960s and 70s through feminist jurists like Ruth Bader Ginsburg. And this, its core assumption is that sex is an immutable characteristic and that, women have been subject to discriminatory treatment on the basis of sex. But at the same time, sex is not exactly like race, meaning it's not purely a social construct. And there are probably instances in social life where sex differences matter. Yeah, you
You
can
say
think of many, right?
sports, right? Yeah.
Sports, yeah. I
Yeah.
mean, anything, physical activity, prisons, all that kind of stuff, right? So, So the heightened review, heightened scrutiny is kind of a slightly less exacting standard of review. So the question in SCMET is, should laws like HB1, of which there are 26 across the country, should they be reviewed under a rational basis standard, as the Sixth Circuit said, or under intermediate scrutiny, as the Department of Justice and the ACLU want? Now, you know, Tennessee, as I said on Twitter the day of the hearing, Tennessee is in a bit of a bind here.
Hmm.
And the reason for that is, in theory, even under a heightened scrutiny, states like Tennessee should have absolutely no problem prevailing on the constitutional arguments. In other words, lower courts can say, yes, intermediate scrutiny applies, but Tennessee more than satisfies that, because look at this medical scandal, right? All you have to do is read the Alabama brief to see just how bad things are.
Okay.
The problem, of course, is that that would constitute a loss for Tennessee, for those of us who advocate for for age restrictions, and it would constitute a loss for the simple reason that you're always going to get some ideological judges who will be just indifferent to the evidence, indifferent to principles of evidence-based medicine, who will be misled, or whose own ideological inclinations will lead them to strike down a law, even if, in theory, it should easily pass intermediate scrutiny. And I think that the DOJ and the ACLU know that. I think that they know that under intermediate review, many states will win, but at least some won't.
Hmm.
But the other critical implication, of course, is that if the Supreme Court rules that intermediate scrutiny applies, that's going to have ripple effects in other areas of policy, because it's going to generate a perception that transgender people now are a protected class. And that, again, is going to have effects in education, in prisons, and other areas of policy. Even if the court explicitly says our decision only applies to youth gender medicine, as we saw in Bostock, that kind of language carries no weight. Within weeks after Bostock, lower courts already said, the court said it only applies to employment and not to bathrooms and stuff, but we're going to apply it to bathrooms anyway. So the bind that Tennessee is in is that it wants the court to affirm the Sixth Circuit ruling and say, no, rational basis is the standard that court should use here. But at the same time, it can't come across as too confident in its case that youth gender medicine is a medical scandal, because if it does, that could send a signal to the conservative justices that, hey, you can rule in favor of DOJ, we're still going to win our lawsuit. So, so both sides are playing kind of a tricky game here. And the DOJ, we can get into that if you want, but the DOJ's arguments are also just very bizarre. Their argument about sex classification is very, very bizarre.
Okay. I'm trying to get my mind around this lawyerly view of reality, or at least just the mechanisms of justice here. So at some point in our history, the category of race became essential to interpreting laws in order to govern how people associate. What was that move a good move for the law as a whole, even if it was a good move for the country where it was? Like, does this talk about some sort of glitch in the law that can be imminently manipulated against reality, truth, and the good of society?
Oh, that's a very heavy and loaded question.
Yeah.
And I admit that it's been a long time since I've given it some serious thought, not since grad school. Look, I mean, I think the reality of the situation was that our constitutional system of government, up to the middle of the 20th century, was unable on its own to deal with the problem of Jim Crow, with the obvious, egregious injustice of that system. And so something had to happen there. And it was not going to happen through congressional enactment. I mean, that only really happened for the first time in a serious way in 1964 with the passage of the Civil Rights Act. But the passage of the Civil Rights Act was itself Congress basically saying, a decade ago, the Supreme Court ruled in Brown versus Board of Education that separate is not equal, but nothing basically has happened since then. The Supreme Court's decision has not really had any effect on the South, on the segregated South. So we're going to pass a comprehensive law that deals with more than just education. It deals with public accommodations, with employment, um, that gives Congress, and more importantly, the executive branch at the time, gives it the teeth to be able to actually enforce the standards announced by the Supreme Court in Brown versus Board of Education. And so the combination of kind of the shift in jurisprudence at the Supreme Court from 1938 all the way to Brown versus Board of Education, and then onward from there, there were a couple of very important decisions after that as well. That kind of laid the foundation for this, what was really a constitutional revolution. This was a revolution of our entire system of government.
Hmm.
Now, of course, people will argue, and there's some plausibility in this, that this wasn't really a revolution. This was making true on the promise of the original Constitution, in particular, its Bill of Rights, its promise of equality under the law. The 14th Amendment, which initially applied only to the federal government, was incorporated against the states in the early 20th century to basically mean that states may not violate, the Constitution's, the Bill of Rights.
Hmm.
Not just the federal government may not violate, but the states themselves may not violate the Bill of Rights.
Hmm.
And so this was a constitutional revolution. There's absolutely no doubt about it in my
Is
mind.
it really bad to say that the government said that we will violate your rights in order to protect your rights in a way? Like was this the seed of government overreach, like dictating on who can associate with who and enforcing who can associate with who?
It's certainly so those implications were certainly already kind of embedded within this revolution, right? And that as a consequence of this, and look, I have a tragic view of reality. I have a tragic view of things. And in my view, this was a necessary constitutional revolution, but it was one whose implications were a mixed bag of very good things and extremely destructive forces that were unleashed on American society that we're still dealing with today.
Hmm.
Um, and it's not clear to me that there was a better path forward at the time, but that doesn't mean that the kind of the negative consequences are not true. They are. Um,
Hmm.
and so it could be that this is just kind of this is our comeuppance for the original sin of slavery, so to speak. That's one way
Hmm.
to try to reconcile it, but it doesn't really matter. I mean, you're already kind of
Yeah. But how
um,
does the rubber meet the road around the gender issue?
yeah.
Child gender
So
issue.
I mean, on this, there's actually a great deal of irony in terms of if we're talking about the trajectory of constitutional development, because the revolution in jurisprudence in the 1960s, 1970s at the Supreme Court, cases like Craig v. Boren, eventually culminating in the VMI case of, I think it was 1989, or no, 1998 or 96. I'm getting my dates wrong. I think it was the late 1990s. The VMI case is the famous Virginia Military Institute case,
Hmm.
where the Supreme Court kind of cemented this idea of laws or policies or any government action that classifies people on the basis of sex, as Virginia Military Academy did, because it only allowed admissions for boys, have to meet an intermediate standard of scrutiny because, sex is a quasi-suspect class. But that whole trajectory from the 1960s all the way to the late 1990s, this was kind of the women's revolution or the feminist revolution, whatever you want to call it, in law and jurisprudence. And it was based on the idea that sex differences are real, they're innate, they're immutable. There are differences between men and women that have social consequences, most obviously pregnancy. But by and large, kind of the guiding principle of these decisions was that, except for these rare instances in which sex differences could matter, and in which case states would have to show that they matter, the strong presumption in American law is going to be that there's no difference between men and women, that men and women are equal in the sense of being the same. That's crucial.
Hmm.
And so this was kind of the triumph of what's known as sameness feminism.
Okay.
Or and um, and one of the things that I've argued in the past, and I'm probably not the first to make this argument, but if you take that principle to its logical conclusion, you arrive at, or if not quite at, then very close to the idea that all differences between men and women are socially constructed, are contingent, should not be, or at least should not have social relevance. And so sex becomes gender in a sense, right?
Hmm.
The distinction between sex as a binary reality and gender as a social system or social construct
Yeah.
becomes harder and harder to defend under this vision of equality feminism. Now that, in itself, that's not an indictment of equality feminism. That doesn't mean that it's false, but it becomes increasing. It's kind of like a slippery slope. It becomes increasingly difficult to
Yeah.
make the case that the differences between men and women matter and should be reflected in social policies if you are, kind of launching an all-out assault on those differences and claiming that, if you look at the law review, feminist law review articles being pumped out in the 80s and 90s and 2000s, it's all about, there's so many articles that are kind of arguing in the vein of, what's always been assumed as an innate difference between men and women giving rise to this disparity actually turns out to be the result of social constructs and oppressive forces and so on and so
Yeah.
forth. So again, kind
Yeah.
of the logic of that
Yeah.
is that what has always been considered to be innate and immutable as differences between the sexes turns out upon our academic inspection to be socially constructed. And it's not a big step from that to saying that sex is assigned at birth, that sex itself is a social construct. And in fact, queer theory kind of matured into an academic, matured is the wrong word when you're describing queer theory, but it matured into its own academic discipline in the 80s and
Yeah.
90s. It was both an offshoot of women's studies, but it also rejected women's studies
Yeah.
because it rejected the category of woman as in any kind of, essential category. Um, but queer theory, you can see the arguments for where we are today are already embedded in that queer theory outlook in the 1980s and 1990s. And
Yeah.
so many of the scholars there were women who were brought up in the feminist tradition and read feminist literature and saw themselves initially as feminists and kind of had a later epiphany. So these
Mhm.
two movements of kind of feminism in academia and law on the one hand, and queer theory culminating in, kind of transgender ideology, sex being assigned at birth, and all that kind of stuff, were really moving in parallel at the time.
Yeah. So this is a might be more of a philosophical question, but so the government can go in and say, you're not treating these people as the same, and that's against the law. So we're going to force you to treat people, these individuals, as the same. But if you have, in Seattle, there's a Korean bathhouse for women that is now under siege via
Right.
lawfare. The government now is oppressing a group, a cultural group, and saying, no, your culture is invalid on our land. We are going to disrupt your culture's view of sex and gender because it's not according to our land. So they're going to take the side of the individual every single time, the individual expressing their desire to have equal treatment and equal access, it would just complete disregard with the culture or the group. But doesn't that trickle back up to race, the category of race as something that should be protected by law? Like if it just so happens that a culture has the same phenotype, couldn't they say, you're discriminating based on our race? According to our race, there is a difference between the sexes, and this is how we behave. And you can't disrupt. It's a violation of our racial identity for you to take sides to impose your culture on our culture, right? This is a really
I'm not sure I follow the logic of all
okay.
that.
No, yeah, I guess maybe it doesn't really make sense, but
No.
the
Well, it might
government's
make sense.
deciding.
Yeah.
Yeah, the government's deciding to intrude in one direction and not the other way. They're not protecting the groups, they're protecting the individual, or they're protecting a certain individual who wants gender care, but they're not protecting the child who could not possibly not be able cognitively to make those informed choices. Right. So how does the law decide how
Yeah.
it's going to impose these tenets, and if those tenets, like if women's rights abut racial rights, other civil rights, like how do they decide?
Yeah, I mean, look, it's a very complicated question. I think maybe the most important thing to understand here is that one of the unique features of the American political system is it's the heavy involvement of courts. Everything is judicialized here, right?
Hmm.
Everybody gets to have their day in court. All of our philosophical and policy debates are sooner or later framed in the language of individual rights. A good example is the abortion debate, which anybody who has given two seconds of thought to knows cannot possibly be a debate between right to life and right to choice, because neither side denies that one of those rights actually exists. It's just a matter of whether the fetus has acquired the moral status of a person such that, ending its life, ending its vitality would be immoral and therefore should be illegal. Um, so, our legal system has, our political culture, our political system has this tendency to reduce these complicated issues to kind of simplistic sloganeering
Yeah.
contests of individual rights.
Okay.
And of course, courts are at both ends of that process, right? The courts are the ones who frame, or I should say litigation, lawsuits, frame these policy and philosophical questions in the language of individual rights, but also if they are framed in that language, inevitably they end up in the courts.
Yeah.
And I think that all these debates about youth gender medicine in the United States are a very good example of that. Because look at Europe. In Europe, okay, so in the UK, of course, the Bell v. Tavistock was a very important lawsuit, but by and large, most of the action in the UK was not in the courts. It was at the NHS. It was at the National Institute, what's it called? NICE, the agency that's responsible for systematic evidence reviews, National Institute for Health and Care Excellence, I think it's called. In Sweden, it's the SBU, it's the Ministry of Health.
Yeah.
In Finland, it's Cohere. So these are not judicial bodies.
Yeah.
But in the United States, it's almost all of it is fought out in the courts. And again, that's a reflection of our political culture, which frames everything in the language of individual rights, which absolutely has happened in this area here, right?
Hmm.
Think about how the ACLU talks about this. It's all about the right of trans kids to get healthcare and the right of parents
Yeah.
to decide on healthcare choices for their own children. And the courts are also at the other side. They're the ones who are actually deciding what kinds of restrictions, if any, will be imposed on this area of medicine.
So that's just the terms of engagement, period. And
I mean,
that's what you get
that's,
when your country is founded by a bunch of lawyers. Then you're just going to
yeah,
have law
right.
ruling.
Yeah, I mean, this individualism, this kind of rights-bearing individualism that
Okay.
has changed its meaning over the centuries, over the decades, I should say, right? I mean,
Yeah.
today's understanding of individual rights is heavily influenced by kind of the cultural and moral revolutions of the 1960s. And it bears very little resemblance to what the founders said when they talked about rights. What they meant are natural rights, the things that we have a right, have the power to do without government interference.
Yeah.
Nowadays, it's a right to healthcare, a right to even recognition, things like these kind of mushy social terms. Um, but yes, our political system and our political culture almost make it inevitable that the debate over youth gender medicine will be framed in that way. And that introduces a lot of distortion. So getting back
Hmm.
to the courts and how they decide these issues, what I think where I trailed off here is judges don't decide these issues at high levels of abstraction. They're not going to look at all the evidence like, Hillary Cass did in the UK. The only reason judges have courts as institutions and judges as individuals who kind of preside over those institutions, the only reason that they have legitimacy, that their word carries any power in terms of policy, right? Because judges have neither the person nor the sword. They can't enforce their own orders. They rely on the legitimacy of their reasoning. The only reason why they have that legitimacy is because they are being responsive to litigants. Judges are passive by their very nature, and that's why they're legitimate. And so judges have to answer when plaintiffs call, and they don't get to choose which plaintiffs or which individuals or which doctors or which procedures should come on the public agenda and be scrutinized first, second, or third, right? So how is this relevant? Well, if you look at most of these lawsuits, Most of these lawsuits, the organizations representing plaintiffs here very carefully chose the plaintiffs they're going to be representing, right? It's almost impossible, although there are a few cases of this, but it's very difficult to find plaintiffs who kind of fit the classic profile of ROGD, which we know is the most common profile of kids who seek transition.
Hmm.
Most of these plaintiffs are actually representative of the more of the most of these plaintiffs come from the far less representative group of, kids who had documented severe gender nonconformity from a very early age, maybe even got a gender dysphoria diagnosis when they were 5 or 6 years old or something like that. There are a lot of boys in these lawsuits, boys who want to be girls, again, which is pretty unusual for what we're seeing in the clinics these days.
Hmm.
But the point is that when a judge looks at gender medicine, the judge is looking at this phenomenon through the lens of the individual plaintiffs and the claims that they make, because the judge cannot make claims on their behalf. The judge is passive. He has to arbitrate between the claims of the plaintiffs and the defendants.
Okay.
And so, and another implication of that is that a judge's understanding of gender medicine or of any social policy or medical controversy or scientific controversy is always going to be heavily filtered through the lens of what the parties of the litigation tell him. And what the parties of the litigation tell him is itself filtered through these complicated rules of evidence. Now,
Okay.
if you think about a scientific controversy, let's say you and I are debating some scientific question and I produce a study that's really, really valuable, really well done, but the authors are all dead. Does it matter to you that the authors are dead? No.
It
The only
shouldn't.
thing that, of course, the only thing that matters is the merits of their argument and their methodology and whether it's good and all that kind of stuff, right? But in court, it matters a lot because you can't if you're going to have an expert tell a judge something, that expert needs to be subject to cross-examination,
Okay.
right? So it's different rules of what constitutes evidence and what types of arguments people can consider as having merit on a particular question. So
Wow.
I'm trying to distill a very complicated topic, and I'm
Yeah,
probably
no,
not doing a very
I guess what
articulate
you're saying is that
job.
the law is in our system very myopic, and that has certain advantages, but it has certain disadvantages.
Well, I wouldn't say that it's myopic. It's just that courts are not the ideal institution to frame these issues and try to resolve them.
Okay.
People have this kind of very high opinion of courts as actually really good at addressing these issues, precisely because you have the adversarial process there, right? You have presumably two parties who each have an interest in winning, making the best possible arguments and rebuttals, and a
Hmm.
judge who is presumably an intelligent person, more intelligent than the average American, and probably more intelligent than the average lawmaker, presiding over the process and carefully giving every argument
Hmm.
attention. That's kind of the ideal of what the judicial process is, but it doesn't work that
Oh
way.
yeah. Okay. Yeah. This is kind of out of step, but you did bring up the LGBT orgs.
Yeah.
You just wanted to talk on them.
Yeah. Um,
I don't know if you're going to frame that in terms of accountability or in terms of their feedback and their pressure on the courts or their pressure on this issue in general.
I mean, their involvement on the legal lands in the legal landscape is, it's of course very important because these are the groups that are partnering with big law firms,
Okay.
kind of white, sometimes white shoe law firms to bring these lawsuits on behalf of these kids.
They're the
Um,
engines driving these suits. Then.
they are, they don't bring necessarily the highest caliber lawyers. Um, because I mean, there are some smart people who work at these organizations for sure, but
Hmm.
the real sharks in the legal field usually go to to the big law firms.
Hmm.
Um, and of course, the big law firms bring all the resources, right? Because it's extremely expensive to litigate. Um, but I think these law firms develop these public interest law firms like Lambda Legal and ACLU, they develop institutional expertise on this issue. Because they've been litigating this issue for a long time, because they have lawyers who are also activists and subject area experts,
Hmm.
like Chase Strangio and Asaf Orr and so on and so forth. Um, they bring a lot of knowledge. Now, it doesn't by knowledge, I don't mean, kind of a sober appreciation of reality and fact. I just mean how to make you
Yeah.
know, how to make
How to win.
how to win a lawsuit by kind of twisting and framing things in a convenient way when it comes to gender medicine or evidence-based medicine, in a way that a judge will buy. And they've become very clever at this. And
Hmm.
I should say that these organizations are also a good 10 years, although I think our people on our side, so to speak, are catching up very fast. But it has been a catch-up game because organizations have been at it for a decade and a half.
Hmm.
Whereas, you know, the law firms, both public interest and private and more corporate, that on our side of the issue, and certainly kind of state attorneys general offices, have only really been at it for 5 years, 6 years maybe. So they're playing catch up. But look, I mean, with regard to the kind of more the broader role of these organizations in promoting gender ideology in our culture and institutions like education, um, I think it's a mistake for people to assume that these organizations, even though they have obviously kind of been captured by trans activists, even though they've obviously pivoted to the trans issue, I think pretty visibly away from traditional gay rights. It's a mistake for people to assume that they represent LGBT Americans. I mean, that's certainly the pretense that these organizations want to create. And that's the way in which they're discussed in kind of left of center media, which, like a
Hmm.
nervous tick, uses this acronym LGBT. There was an article in the Washington Post yesterday, the day before, that the headline was something like LGBTQ Americans are stockpiling medications in anticipation of what the Trump administration is going to do on gender medicine. Really? Gay and bisexual and lesbian Americans are stockpiling medications?
Hmm.
I wasn't aware that you need to have medications to be lesbian. But this is a good example of how the kind of the knee-jerk use
Yeah.
of this acronym LGBTQ, which is marketing, right? It's
Yeah.
pure marketing, and it's a brilliant strategy that trans activists have used. Um, so, yeah, again, it's a mistake for Americans to believe that there's unanimity among all Americans who identify as lesbian, gay, transgender, bisexual. No, there's a huge difference of opinion and bitter internal feuds, only a small fraction of which is visible to the public. I see some of those feuds behind the scenes because I have sources in that world.
Hmm.
But I can tell you that even within these organizations, there's a civil war raging. In places like the ACLU, there is profound discontent
Really?
with, oh yeah, with where activists like Chase Strangio have taken the organization, kind of the public image that they've given to it.
Hmm.
Because, you know, Strangio represents kind of this young, what I've called a dorm room Marxist outlook on society. Strangio has said things like, I'm a constitutional lawyer who doesn't believe in the US judicial system or the Constitution. Strangio has called for the abolition of marriage as an institution, said that, you know, same-sex marriage was a mistake. All the kind of the
Hmm.
arguments of radical queer theorists from the 1990s in academia you
Hmm.
can find on Strangio's Twitter. That's decidedly not what these kind of mainstream gay rights organizations were saying up until 6, 7 years ago.
Yeah.
Um, and that's probably not what a lot of their deep pocket donors and foundation donors want them to be doing and saying. Um,
Hmm.
but, you know, as I've found out, there's just a lot of fear among kind of the old vanguard of gay rights activists, you know, kind of people who are 40, 50 years or older, who cut their
Yeah.
teeth on issues like marriage and employment and so on and so forth. There's reluctance to speak out because, number one, they don't want to be seen as kind of cooperating with the religious right, which is how it's always framed. And number two, I think for a lot of them, there's also a lot of sympathy for people who identify as transgender. And they, to some extent, see themselves in transgender identified people, meaning here is a minority that is misunderstood, that's
Hmm.
maligned by society, that's misunderstood, that is denied certain rights and privileges. You know, they may have some cognitive dissonance about this, meaning they may have, I've seen this in some cases
Hmm.
they say, no, this is kind of bullshit, but in other cases say, no, no, I can see why this is a valid set of claims. But there is some sympathy there too. But I think there is kind of growing realization within the ranks of these organizations that something has gone terribly wrong. And if they don't correct course very quickly, they're going to spend all of this precious social and political capital that they've built up over generations, since the 1960s at least, if not 1950s, in a way that they're going to find it very difficult to gain back.
Yeah. So once we're trying to adjudicate morality through the blunt instrument of the law, society's already kind of on shaky ground. Do you see a cultural shift occurring? And does like the federal level Trump reelection forebode some societal change on a deeper level?
So I'm going to say yes with an asterisk. Let me start with the asterisk. The asterisk is, and I think we saw the asterisk in full force during the first Trump administration, is that anything that Trump does for the anti-Trump crowd, which includes, anybody who's left of center or even right of center, but anti-Trump, anything that Trump does is automatically going to be, suspicious. And during the first Trump administration, LGBT advocacy groups, or let me rephrase that, transgender advocacy groups that bill themselves as gay rights groups, really took off. They got huge donations, infusions of cash. They got they managed to make a very powerful appeal to a young generation of lawyers kind of bubbling up through the elite law schools to say, give up your corporate career ambitions and come work for us. And they did that very successfully. So I remember reading a human rights campaign memo that was written, I think it was in 2019. I can't remember the exact year. And the basic message of the memo was the Trump years have been very bad for LGBT people, but very good for LGBT organizations.
What does that say about their priorities?
Well, I mean, look, this is a very common phenomenon, right? NRA does spectacularly well under Democratic administrations.
Okay.
Planned Parenthood does spectacularly well under Republican administrations, right? That's kind of where all the discontents throw their money and attention onto these public interest organizations. So
I should get into I should get into that racket.
Yeah, I mean, right. And you can pivot based on who's in
you just
office,
pivot.
Right? You could be a total grifter, not just a partial one.
No, full service grifter.
Right. So the asterisk here is that, even if the Trump administration is dead serious about tackling this problem and does a really good job of it, which I hope is going to happen this term, in being effective, it could actually end up, greatly benefiting this whole industry, transactivism industry in civil society. And of course, the moment Democrats come back into power, that renewed civil society industry is going to have a massive influence over the Democratic Party, right? So that's the asterisk, and it's a pretty significant one.
Wow.
But look, I mean, yes, to answer your question, there has been and continues to be a profound shift in the culture. We are no longer in 2017, 2018, where people think that merely questioning the dogmas of the transgender movement is a death sentence. I think people can now openly say things like, a woman is an adult human female. People can openly say things like, I think kids should wait until they're mature adults to get their body parts amputated. I think prisons should be single sex and transgender women should be in men's prisons or have their own ward. I mean, it's no longer controversial to say things like that, except for in kind of radical progressive circles. So in that regard, there has been a profound shift. And you can see this reflected in public opinion polls. Now, public opinion polls are very imprecise instruments, and they're more often than not, they're very sloppy because the way they phrase questions, they'll ask things like, I've seen this in like Gallup polls asking people things like, do you believe that there are only two genders assigned at birth or more genders assigned at birth? What a ridiculous question. But you can see that, so it already comes loaded with all these ideological assumptions. So how do you even begin to tackle that, right? But if you look at public opinion polling, you see these very clear shifts. So, there was a YouGov poll that was recently published that showed that only 19% of the public believes that children should be offered puberty blockers.
Hmm.
19% of the public.
Hmm.
So that means that 81% either says that kids shouldn't get puberty blockers or is unsure.
Hmm.
I think the breakdown there was something like 50 something percent said should not, and 20 something percent said unsure. I think that was the breakdown, but I may be wrong about
Hmm.
that. By far, I think, though, the most destructive policy for trans activists to have pursued in the last 6 or 7 years, by far, in terms of public opinion, has been on the sports question.
Hmm.
And I remember saying something about this in 2021, 2022. I had a couple of articles on the Leah Thomas affair, and I remember having some conversations and appearing on some podcasts and saying something then to the effect of, yes, gender medicine is a medical scandal. Yes, once you understand what's going on there, it's horrifying. But at the end of the day, that's not what's going to move public opinion nearly as much as the sports issue. Because to see a 6'4" man with, an intact man, clearly wearing a woman's Speedo with a huge bulge, and, his stature is twice or three times that of the women standing next to him, and he absolutely demolishes them in the pool. This is going to become more common, not less. And every single Leah Thomas is going to be a massive liability for the trans movement in terms of public opinion and culture.
Hmm.
A massive liability.
What does that
So,
say
yeah,
about human psychology or Americans?
that's a good question. I've thought about that quite a bit. That people want to be nice and polite, and they want to not say things that will get them in trouble socially, but they cannot ignore what is obvious to their eyes, right? They cannot ignore this obvious reality. And so I think people who are kind of left of center on this issue and not so-called gender critical, I think people like that live with some degree of cognitive dissonance. And I see this, I
Hmm.
live amongst the libs, so to speak, right? And I see this in my own environment. People who outwardly profess to want to be respectful and affirming and this, that, and the other, and pro LGBT, and they'll even look at me and what I do with with a little bit of suspicion. But then as soon as you talk to them, you realize they agree with you on 98% of the issue.
Hmm.
They just don't want to say so publicly. So I think there's just a great deal of cognitive dissonance. They know what they should believe, but they also know what they actually believe, and they don't
Yeah.
know quite how to reconcile those two things.
Yeah. Do you feel a shift happening in those elite climbs where
Oh
people
yeah.
are kind of
Yeah,
calling
and it's
bullshit?
and it's a shift. It's again, it's not a shift necessarily of changing minds, although in some cases it absolutely is. But I think more and more it's a shift of just feeling comfortable to say out loud what they know to be true.
Hmm.
Now, let me say one last thing, which is, um, have you ever heard of the contact hypothesis? This is a scholarly theory that, kind of emerged in the context of gay rights. And the idea was, or it could have even been in the context of racial civil rights, but it certainly was proposed in or used in the context of gay rights. And basically the idea here was, as individual citizens get to know more and more gay people, and as gay people become more visible in society, and you get gay neighbors and gay dads or moms in your kids' school and so on and so forth, and you interact with them on a daily basis,
Hmm.
people's view of homosexuality will become more positive. And that seems to have borne out. And I personally regard that as a good thing. I understand why social conservatives might not. Setting that aside, um, what's interesting is that I think there was kind of an implicit faith in the trans movement of a decade ago that the contact hypothesis would bear out for them as well. And you can see that in the literature of the mid 2010s. You can see this kind of emphasis on greater visibility and this assumption that with that greater visibility will come greater understanding and greater acceptance.
Yeah.
That has not happened.
Like by means of Jazz Jennings or Bruce Jenner, I can't
Yeah,
remember
and
gender.
Laverne
Yeah.
Cox and so on and so forth, right? I mean, so these kind of trans icons that, in other words, the assumption was that the more the public is exposed to transgender people, including through personal day-to-day contacts, the more sympathetic they will become to the transgender movement's philosophical claims.
Hmm.
That has not borne out. In fact, if you look at the trajectory of greater visibility on the one hand and public opinion on the other hand, you see that the exact opposite has happened.
Yeah. Okay.
The more that transgender people have become visible, the more skeptical the public has become towards the transgender movement's philosophical claims about the nature of sex differences, what it means to say that a person has a gender identity, whether kids can be transgender, what it means to say that, and how
Mm.
society should treat these kids, sports, on all these issues,
Yeah.
the public skepticism has grown alongside the visibility of transgender people. And I think that that's very interesting, and that tells you something about the underlying merits of the transgender movement's claims about and on society.
Hmm. Oh, well, either that or society just won't stop oppressing them. I mean, they could be right the whole time, and it's just like normative society is just like on this point being very stodgy. And
Well, that's certainly what they argue, right? They argue that the last decade has seen an increase in what they call cisnormativity and transphobia.
hmm.
But if you think for 2 seconds about how they define those terms, what they're really saying is they're defining cisnormativity as society's refusal to accept that sex is assigned at birth, that all humans have an innate gender identity that's
Yeah.
subjectively and infallibly knowable, and so on and so forth. So by their understanding of cisnormativity, 100%, society has become more cisnormative, and that's a good thing, right? We want society to be cisnormative in the sense of acknowledging certain basic truths about reality. That's not a
Yeah.
bad thing.
Yeah.
Now, of course, if by cisnormative they mean, you know, people having irrational fear and hatred of people who don't identify as their own sex, I think I would push back on that at minimum by saying that at least some of this fear and hatred is perfectly rational. Maybe not the hatred part, but the fear is perfectly rational. It's perfectly rational for women to fear sharing prisons with men convicted of sexual assault. It's
Hmm.
perfectly rational for parents to fear having their young children exposed to transgender concepts in kindergarten. In fact, it's somewhat irrational for parents not to be worried about that.
Hmm.
So, setting aside hatred, which itself has become a concept that's been stretched so thin that every form of even mild disapproval now is called hatred. Um, yes, society has become more cis-normative in the sense of being more sex realist, and that's a very good thing. And I think a great deal of that, if not most responsibility for that change in culture, is precisely because of the transgender movement's overreach.
Hmm.
Leah Thomas being a very good example of that.
So, one comment that I've heard in my research into this issue is that transgender or trans rights came to the forefront in the wake of the victory of gay rights for gay marriage. That
Yeah.
these institutions that had a bunch of monetary and social capital didn't know what to do, and they had to keep on going. They couldn't disband. It's like it's a
Right.
perennial problem of the activists that once you win, you're like, well, I have to get something else. What about you? Like if this issue got to a place of acceptable equilibrium, let's say,
Hmm. Hmm.
where would you be? How heartbroken would you be? And what jihad is next?
Yeah, what's my next jihad? Yeah, so first of all, I have made the institutional inertia argument. I've been making it for a few years now, and I think there's plenty of evidence to support it that after, especially the Obergefell decision, the same-sex marriage decision, these organizations basically faced a choice of pack up and go home,
Yeah.
or kind of pivot to something that's analogous that retains donors and talent. Look, if first of all, I don't think that we're going to reach any form of equilibrium in the next 5 to 10 years. I think the battle over blue states is going to be long and very difficult.
Hmm.
Um, uh,
So you've chosen your path with like forward thinking and
well,
career terms.
it's more, the path. I'd say I partly chose it and it partly chose me,
Hmm.
just because of my dissertation interests and how they kind of grew and just kind of naturally grew into what I'm doing right now. But I would be very happy to be at a point in my career where I'm not 2 seconds from retirement, that I still have, a good 10 years, let's say, to develop expertise on some other issue
Yeah.
to completely change topic. I would be perfectly happy with that. I
Mm.
do not want to be talking about, carving up kids and giving them drugs for the next 15 years.
Yeah. Yeah.
Now, given, everything that I've learned about evidence-based medicine, about the US healthcare system, about how the interaction of science and law and all that kind of stuff, I'm probably, if I do pivot to some other issue, it's probably going to be in that general region. It's probably not going to be
Right.
something completely different, like immigration, although who knows?
Yeah.
Um,
But I mean, there
but
seems to be these chronic scandals. So there's something amiss
yeah.
in the medical
Yeah, and in
industry.
fact, I'm working on an article right now that it could actually grow into a book, but for now it's an article that tries to say, look, everybody has been claiming that the reason gender medicine exists as it does today is because it's exceptional. It's been kind of exempted from the normal standards and expectations of medicine, of evidence-based medicine. Um, I argue in this piece that if you actually understand the US healthcare system and you start to look example by example at other medical scandals, not even scandals, just basic practices that are still at play today that are not backed by any credible evidence, you see that actually so-called gender affirming care is perfectly consistent with these enduring pathologies of the American healthcare system.
Mhm.
Yes, it does have some, kind of added elements of ideology. Of course it does. But we have to understand that there are these enduring problems with the US healthcare system that make reform very difficult.
Mhm.
So that's something that, I could see myself talking more about, kind of medical policy making and stuff like
Yeah.
that.
Yeah. You think you'll ever get into teaching if you don't do that now?
Well, first of all, I would be getting back into teaching because
Back
that's
in,
what I
yeah.
did
Okay.
before doing
Yeah.
what I'm doing now. I would love to. I
Yeah.
mean, I've been offered several opportunities to teach courses, university courses since starting at the Manhattan Institute. I just don't have time.
Yeah.
But being able to go back to teach, American politics, introduction to American politics is a course that I taught quite a bit. I'd love to do that.
Mm. Well, Leor, thank you very much for your time. You're a super busy guy. This issue is it's really complex, so it's always necessary to kind of refamiliarize myself with all the different mechanisms that are in play in this issue. What do you think is going to be like the short term, the SCMET? When's that resolve? And like what's if the people who are interested in that, what do you think is the most important thing for them to be paying attention to right now?
You mean with the Skrmetti case
Well, the Skrmetti
itself?
case or anything
Oh,
else involving this issue, like what's the key issues right now? I guess Skrmetti is the
yeah.
top.
Skrmetti is obviously important because it's the Supreme Court and it's getting a lot of visibility. I'm not
Yeah.
sure it's actually the most important thing happening in kind of in the general, let's call it the reform movement.
Hmm.
Um, I think we can expect a decision probably in the summer of
Okay.
2025, or potentially sooner, but probably in the summer. Um, but again, keep in mind the decision, at least in the short term, applies only to red states because it only applies to bans, right?
Hmm.
I think the far more significant and impactful actions are in the detransition lawsuits, and those are very difficult to win.
Hmm.
I should maybe just say very quickly that with other types of, healthcare related or medical torts, tort is, kind of civil wrongs. Other examples like Agent Orange have invited class action lawsuits. And the huge advantage of a class action lawsuit is that it has a massive payout.
Yeah.
Because if you have tens of thousands of plaintiffs, payouts can be in the billions of dollars.
Yeah.
And if you
Talk about
have massive,
incentives.
exactly. And if you have massive payouts, that attracts top law firms, right? They say, I want to get in on this action because if I get a third of a $1 billion payout, that's $300 million. That's a lot of money.
Hmm.
Um, you can't have, it's virtually impossible to have class action lawsuits in gender medicine. Um, partly that's because of statutes of limitation issues that are 1 to 3 years. So one of the things that states are going to be focused on in the next year is reforming statutes of limitations.
Okay.
Partly it's because You're not dealing with a single unified defendant, let's say a manufacturer or something like that. You're dealing with lots of different gender clinics and gender clinicians. And partly because detransitioners, by their very nature, are difficult to gain as plaintiffs, because these are, often by the time they realize they were harmed, they're still kind of struggling with mental health problems and stuff like that. And it takes them a few years to get past that, to really mature into adulthood. So, it's very, very difficult. So you have to kind of litigate these cases one by one. And so that's, I think, the far and away the most important thing that's happening right now.
Yeah.
And so I think people should be paying attention to, the lawsuits filed by Prisha Mosley. I think that lawsuit is at the most developed stage at the moment. And it's at the most developed stage because if memory serves, the court did not grant her claim of medical malpractice, but rather of other types of harms. So the case has proceeded, I think, to discovery on these questions of other tort harms. And then, of course, the lawsuit with Johanna Olsen-Kennedy is going to be massively important. But one last thing I should say about this is that even though these lawsuits are, valuable in and of themselves for producing verdicts and that have financial consequences, the discovery that comes out of them is no less important. Right? The depositions, the cross-examinations. I mean, so much of the most valuable information that we've gotten about gender medicine in the last 5 years has come out of depositions done, or subpoenas, I should say, and depositions and cross-examinations in the state bans. And I've spoken to people who told me when the states first started passing bans, they said, oh, this is not the way. Even I was skeptical of state bans. I had an article in City Journal saying, expressing that skepticism. But people were saying, oh, this is not the way, and it's not, it's going to backfire, and it's going to lead to retrenchment, and this, that, and the other. And I could see the logic back then, but the truth of the matter is, had states not passed these bans, we wouldn't have known everything we know today about WPATH. And it's that knowledge that's going to be massively important in these detransition lawsuits.
Okay.
And in broader state federal investigations and fraud allegations and all that kind of stuff. Bringing down this industry is going to depend on the information gleaned from these state lawsuits.
So you brought up, just a little point of order, you brought up that according to the law, if you bring them a paper and they can't cross-examine the writers of the paper because the writers are dead, like it's really tenuous. But if all these documents and depositions and stuff are already embedded in law, then it's a part of the law. So it's like kind of like uploaded, and they don't have to re-adjudicate it or
not exactly. No,
but
exactly.
I mean, all this information isn't just for public opinion's sake, but it
has staying power in the form of precedent, right? So let's say that Prisha wins her lawsuit, which I absolutely hope she does. And let's say that the court in that case finds that, that in fact the doctor breached the standard of care, breached the duty that the doctor had, or the Rafferty lawsuit, or the Johanna Olsen-Kennedy lawsuit, right? So if we get good verdicts there, subsequent lawsuits filed by detransitioners will be able to say, look, several courts have already considered the evidentiary record here. The court, that should be instructive to the court. The court should look to those cases in trying to decide this one as well. It doesn't mean that they're not going to have their own evidentiary record. They are. Yeah. But it's going to create momentum and make it much easier for future plaintiffs to win.
Okay. So it's the decisions that have the staying power, or like more input into the system rather than the process by which the decision was reached, or the evidence upon which it was reached.
Well, it's both, but the decision itself is going to have the main impact. Yes.
Okay. Yep. So I guess where can people find your ongoing publications, your works, and
So my profile at the Manhattan Institute has all of my writings, not just at City Journal, but anywhere that I've published. Anytime I write something, I put it on Twitter. So if you follow me on Twitter, you'll get everything I write. And then you can always Google me and just scroll down past the transgender map.
Yes, I'm on there too. Did they commission a painting of you?
Oh yeah. I look like a Colombian drug lord. I mean, I love my painting. I think
look like a methed up Billy Bob Thornton, actually.
I'll have to take a look at that.
Yeah,
I
I'll have
I
to put
love
yours.
my drawing. I'm thinking of borrowing it and just using
Put
it
it
in
on a
other
mug
contexts.
or
It's
something.
great.
Yeah, no.
Yeah, no, it's that's a really good idea. I'm actually going to put it on my on a mug. That's a really good idea. Yeah. No, I love it. I look like a sexy Colombian drug lord. It's way too flattering.
Yeah,
But I'll take it.
the mean Sapir. Yeah, cool. Well, thank you very much for your time. I'm going to end the
Thank
recording
you,
and
Benjamin.
I'll link to all your work down there in the description. Have a good day. Later.
Awesome. You too. All right, bye-bye.
Cheers.